Okay, as United Appliance Servicers Association, we want to welcome you all to our part 2 webinar of our 3-part series. What you didn't realize you didn't know, and tonight we will be focusing on liability. Renee Galeotto is our moderator this evening. Renee?
For showing up tonight. I know we had to reschedule this, so thank you so much for rearranging your schedules and being here tonight. So I want to start with Neil, if you'll unmute, tell everybody who you are and what company you're with.
Sure, I'm Neil McConico. I work for Clay & Land in Memphis, Tennessee. I'm a third-generation insurance agent, mainly specializing in appliance service and repair and appliance stores.
Thank you, Neil. Fred, tell us who you're with.
Oh, I'm sorry, were you talking to me? Yes, my name's Fred Statham. People know me as Buddy since I was small. So I answer to either one. I'm a partner with Manier and Harrod law firm in Nashville. We're about a 30-person firm. As of November 1st, I believe, I will have been licensed for exactly 30 years. So my specialization is litigation, and more particularly defending on the defense side of litigation, civil litigation, and most of my cases are assigned by insurance carriers, and I do liability, general liability, professional liability, attorney, accountant, malpractice. I do employment defense law, and I do surety and fidelity. And you can look at my profile on the website, and it goes through. I've handled just about every kind of defense litigation case that you can think of through the years. And so I really appreciate and enjoy the opportunity to I guess, use some of what I know from litigation and talk to folks who have specific questions and as they apply to their particular lines of work. So thank you very much for having me here this evening. This is I'm not put upon at all. I really like to do things like this. So
thank you so much. We're glad to have you. And Tyler, tell us about yourself.
Yes. Well, first of all, I will echo Buddy's sentiment regarding the ability to speak tonight. We definitely welcome the opportunity to discuss a lot of these issues, especially ones that are facing members of your association. My name is Tyler Sanders. I'm an associate with Manier and Harrod here in Nashville, Tennessee, focusing primarily on litigation as well, but particularly with a focus on workers' compensation defense. So most of the work that I'm working on is defense of insurance carriers, their third-party administrators, and of course that trickles down to the employers themselves. Everything from your slip and your falls to your more complicated death cases. But workers' compensation is one of the big areas that I focus on, in addition to some of the more traditional litigation areas, such as your employment law defense, such as your general liability defense, things like that. So I've been with Manier and Harrod for a couple of years now, and before that, clerk for a judge. So very happy to be here and answer any questions we can.
Thanks so much. I appreciate the information so everybody knows who we are and what we're going to talk about tonight, a variety of subjects, and those are going to deal with some liability, of course, some workers' comp issues and questions that are coming into play, and I'm going to do it from a standpoint of certain situations. I know I'm not going to touch on everybody's situation, so hopefully I hit some and I answer some questions for a lot of people, and maybe it fits into a situation that you've had or maybe you've been concerned about for some time. So first we're going to open up the conversation about waivers of subrogation. Now, some of us in the industry are seeing these circulating with contracts that we have with different companies, whether it be a third-party administrator or a manufacturer OEM. So first of all, I know you all know and have information on this, so I'm going to go with Fred first. Tell us in plain terms, what is a waiver of subrogation?
Sure, and thanks for our conversation earlier today in explaining to me the context that it comes up the most in this field. A waiver of subrogation clause is, for example, it's my understanding that y'all have contracts, or some of you have contracts with appliance manufacturers. And in order for that manufacturer to hire you or contract with you, they ask you to sign a waiver of subrogation. And what that typically means, I think, is that, for example, if one of their products that you guys install or service or something like that causes an accident, causes an injury, whether to property or to person, that if you are sued by the customer, by the homeowner, and you have to pay, or your carrier believes that you may be liable and pays an amount, the carrier, your workers' comp, your liability carrier always has a subrogation clause in their insurance policies. Invariably, they will pay you, but what you do is give them the right to go back against who actually caused the accident, and in this case, a product manufacturer or product manufacturer you contracted with. Well, what you've done, if you have signed one of those waivers, is in most instances, you have probably breached your insurance contract, because just about, unless there's a specific endorsement, just about every liability insurance contract says you agree on the front end that you will not do anything to impair their right of subrogation. They're your insurer, and they're going to take care of you. And if they do, you're not going to do anything that keeps them from going against your manufacturer. Well, if you sign one of those waivers of subrogation, you have done that. So it is extremely risky to do that. The better course of action is, if you're asked to sign one of those, go to your broker, to go to your carrier and say, look, they're asking us to sign a waiver of subrogation. So in order to get this contract, we have to do that, but we want to notify our carrier. And at that time, the carrier will decide whether or not they want to continue. They will either tell you, we will not cover that, or we'll include an endorsement in your policy, but it's going to cost you more money, because if you waive their subrogation rights, it increases their risk of loss. And then insurance premiums are all based upon risks and things like that. So I printed off, and thank you, Tyler, for actually finding this. A carrier will, if the premium is right, include an endorsement that says that that they waive their right of subrogation. So an endorsement like this will allow you, if you pay for it, will allow you to sign those waiver of subrogations with your manufacturer. And your carrier is agreeing they won't go against anybody. They will just handle the claim. But again, that is invariably going to increase your premium if they will do it. So, that just popped up. I had nothing to do with that. But you see, we waive any right of recovery we may have against any person or organization shown in the declarations, or any person or organization with whom you have a contract that requires such a waiver. So, and looking through this today, knowing this was going to be a topic, some other considerations. If you're asked to sign one of these, you should see if you have the clause in your insurance contract that prohibits you from impairing subrogation. And if you do, you've got to go and say, well, they're asking me to sign this. What would it cost me to get a waiver of subrogation? Or they may not. You may be looking for another carrier. But also, when you're renewing your insurance every year, if you go with a different company, be mindful of the fact if you have signed any of these in the past. And the better course of action is to notify your prospective carrier that some of these may be out there, because you've got that policy without the waiver will invariably contain the clause that says you will not impair their right of subrogation. So
is this a piece of paper that stays on file? In other words, if the contract renews every year, should this renew every year, or is this good forever and ever? Amen.
Oh, with the carrier, a waiver of subrogation? No, it's got to be.
with the person you're signing it, the one who asked you to sign it, if they send you a new contract every year, should they send you a new waiver every year, or is one waiver, are you done?
If it is in fact a new contract, then they should send you a new waiver. If it is in fact a new contract, it should say something about it dragging along the old waiver of subrogation. Be sloppy on their part not to cover that. I mean, it's going to leave the door open for that kind of argument.
Okay. Neil, I know you're probably ready to get in on this. Tell me what insurance thinks about waiver of subrogation.
Most of the time, and when I'm talking specifically about servicers, we deal with this almost daily. Most of the general liability that we sell is going to come with a blanket waiver of subrogation. However, a lot of these warranty companies, that's not good enough for them. So they are wanting a designated waiver of subrogation, which even goes a step further. You are really signing your rights away to some degree. However, if you want the business, you're probably going to have to issue this waiver of subrogation to them. I'll let the attorney speak on this. If you've signed a waiver of subrogation and let's just say the manufacturer was grossly wrong and you've given them a waiver, is there any way to go back on them? I don't know the answer to that.
Okay. Sure, I'll address that. And I've had various scenarios in which you consider what their actual waiver says,
Right.
And you have to look at the language of that. And basically, it's a waiver of liability on the part of the manufacturer. And we'll get into some waiver of liability issues a little later, but I mean. Anybody can contract, it's in the Constitution and they'll be enforceable, but waivers of liability, and may not fit exactly into the waivers of subrogation. The Tennessee Supreme Court a couple of years ago, 2018, laid out some new standards to be considered. They're going to be construed a lot more strictly, or they're going to be scrutinized a lot more by the courts. Used to, they were just enforceable, but there's a public policy against basically assigning to someone else your liability for your own wrongful acts. You can do it, but you can do it if it's negligence, but the waiver must specifically set forth what the person signing it is giving up. And if the manufacturer, for example, wants to be exculpated for their own acts of negligence, they can do that. And it will be enforceable, but it better say exactly what they're exculpated for. And it better say very clearly that what you are signing says that nobody can come against me, even if we are negligent. And that will be enforceable if it's clear enough. And so there are other factors to look at to see if it's if those are enforceable. But more recently, it's going to be looked at a little bit harder. If you sign, going back to the waivers of subrogation, here's something I would do if I were asked to sign one by a manufacturer. Shoot it over to your lawyer. In Tennessee, if the manufacturer's waiver of liability doesn't say we are exculpated even if we are negligent specifically, then as your lawyer, I'd probably say, well, that's not enforceable anyway, not going to be in Tennessee. The other thing is no party can have another party take on their responsibility for intentional acts or even gross negligence. So if it says that, that's not going to be enforceable as against public policy.
Okay, so we have a follow-up question, Fred. Why would a manufacturer or a third party ask someone to sign this waiver of subrogation? And that might be more of a Neil question too. Sorry.
To absolve them. Let's say that there's say the manufacturer's product that you guys install badly injures a third party, and we believe it's because of the manufacturer, but your insurance carrier pays for the, for the loss. Nobody can come after them. Nobody can bring them in. Your carrier can't, and they step in the shoes of your of you guys, and if you can't do it, they can't either. I mean, they could. In Tennessee, we're not a first party state in terms of the insurance carrier bringing the action. They would bring it in the name of the insured, but you'd be stopped from doing that. I mean, basically, they walk from it.
So we have another question. Should we sign waivers of subrogation? That you should talk to your attorney in your insurance carrier.
Yeah, I would love, I mean, if it were my client, I would just love to see it. First of all, let's look and see what it says. See if on its face it comports with the current state of Tennessee law. Would it be upheld anyway? I mean, if it's not going to be upheld and they insist upon it,
Okay, and then
you might have a judge get it wrong. But
yeah. We have kind of the opposite side. Would we want to put a waiver of subrogation into our customer contract on the invoice?
Yeah, and I think those are more called or referred to as waivers of liability.
Okay.
What do you have to lose? Absolutely. And subject to the principles I've already spoken about as to whether or not it's going to be enforceable, you can't exculpate yourself from your own intentional acts or gross negligence. But if you spell it out very clearly, all the things that they are giving up in the bargain, I mean, you have to very carefully spell it out, and I would have your attorney write it up for you. It can be enforceable. It can be enforceable in Tennessee. And I'm speaking from Tennessee. Other states may take a harder look at these waivers of liability, but unless you're contracting with a minor or you're trying to get out of gross negligence or intentional conduct, absolutely. It's just got to be very, very, very specific. Now, you might put your customer off by saying, what are these people going to come in here and do? What am I taking? What risk am I taking on here?
Well, let's look at it a little differently. When we're talking about a waiver, and I hear a lot of people in the industry, and this has been a conversation, around dinner and things like that at different times. So a lot of us have our own waivers drawn up, a waiver of liability for water damage or flood or whatever the case may be. And I'm going to let Tyler weigh in on this a little bit too and give him an opportunity. What are those? Are they worth the paper they're written on, or is it a waste of our time to do that? Can a customer or consumer come back on us anyway, even though they've signed something like that? Tyler?
That's kind of a two-part question. Can they come back on you? Absolutely, right? You've got attorneys out there that will sue for anything and everything that they can get their hands on.
Right.
But generally, yes, those contracts are going to be worth their writing in the paper. Buddy has kind of made clear that, again, speaking in Tennessee and looking at the law, this is sort of the national trend. The key here is just to be as specific as you can as possible in these. So, you're waiving all liability for me to come in your house, including anything that I do that's negligent. Using those specific keywords in there, like negligence, is going to be very important. Now, again, national jurisdictions are very different, and they all have different standards. They all have different rules. But one of the key factors in Tennessee is just how clear did you make in your paperwork that individual signed that they, in allowing you to come in their home and repair their, washer, dryer, whatever they're having to repair, as clear as you can make that. And I'm talking about bolding it. I'm talking about underlining it. I'm talking about putting it in all capitalizations. Anything you can do.
And by then you might have scared your customer to death.
Well, there's always going to be a fine line, right, between those two things. But
Tyler's correct.
Is make it as clear as possible. And then, they're certainly worth something. If nothing else, then, when the person thinks about suing it and they look at that contract, they're going to see that, just because they were negligent and not putting that hose in correctly or something else like that, I still can't sue on that basis.
Well, then let me ask a ridiculous question then. So let's say that the home is owned by multiple parties. okay, a husband and wife, maybe it's a beach house that's owned by, brothers or something. One of them signs the waiver, but the other do not. Where does that leave us? Can the others come? I mean, I understand the concept that we can be sued for anything at any time, but is that a legitimate, does one party have the right to sign away everybody else's, liability rights?
I don't think so. What's the nature of the injury? Is it property damage or is it?
I would say property damage. That's what we get hit with most, I think.
If one of these persons who didn't sign it came in and broke their leg on water leak that you caused, and they didn't sign a waiver of liability, then I think I think they can.
But specific to the property, though,
if it's damage to
like
the
if it's a
property,
leak. Yeah.
if it's damage to property that the three of them or different people own and only one signed the
Right.
waiver. Well, let me say for the first time tonight, that's a good question.
I knew I had it in me.
To the extent that, I think the general rule is if you don't sign a waiver, then you're not bound by it unless there's something in there, and maybe they're partners or there's something in their joint ownership.
Husband and wife.
It's most likely
the signature by one does not bind the other.
Okay. That's my question.
Necessarily does not. I actually ran into this in a really bad banana boat accident up in Kentucky, and there was an exculpatory clause it was a camp, and the camp had the parents sign the exculpatory clause that we're not, can't be liable for ordinary negligence or like that. And we would have gotten out of this entire thing, but only the mom signed it.
Right.
Didn't have mom and dad sign it. So.
Gotcha.
Well, let me add something, Renee.
Go ahead.
A lot of the servicers, some of them, and I'm going back to the waiver of subrogation. Sometimes we issue 200, 300 certificates a year for some servicers. Every one of them have a little bit different requirement on that waiver of subrogation. If I'm hearing Buddy and Tyler speak correctly, you almost have to take an attorney with you on every appointment and draw up a contract specific to that house. And that's just unreasonable and can't happen.
And the service call just went up, didn't it?
The service call went up greatly.
Yeah.
I'm sure Buddy and Tyler would love to make service calls.
I think that there is probably a template that you could use to tweak a little bit.
That's where I was going with all this.
Yeah.
Yeah.
Overall, we'll just say that we're better with it than without anything.
It doesn't hurt anything. And we're looking at some examples today, and I would go so far to say as some of the clauses in there are to the effect that to the extent that any of this is not enforceable under the law of the state, one of them was Pennsylvania, it is enforceable at least to the furthest extent that it can be, something like that. So,
gotcha.
Now, the one thing you simply can't say is that you waive liability for any and all injuries. That kind of language will never be enforceable.
Okay.
It's got to be more specific than that.
That's good to know, though, because I've seen those kinds of waivers out there.
The old forms, there are a lot of them, and some case law in Tennessee more recently has picked those apart.
So let's dive a little deeper, and I'm going to give you certain scenarios because we run into these in the field, and I think it's probably plagued a lot of us over the years just knowing what to do. So it is inevitable that at some point we're going to damage somebody's floor. It's not intentional, but it happens. So I don't know about anybody else, but if I damage somebody's floor, they've got imported teak from a foreign country. It cost them $2.5 million to put it in. So am I liable for the entire downstairs because they cannot match that color if they tried? Or am I liable to fix the 2 scratches I put in the kitchen? Because we've all been in that situation where the customer is trying to dictate what they want to get out of this mistake. And, so you're in a situation where I'm trying to figure out, am I at their mercy or do where do we stand on that?
Here's where your waiver contract would be very important. If you know that you're
Sure.
going in there with an almost irreplaceable floor, how would it come out in the courts? You'd have people testifying on both sides as to the cost of they can recover their reasonable cost of repair. And what is reasonable is a fact question. And if they bring in an expert that says, this cannot be replaced anytime, anywhere, and they ruined it, and fixing 2 scratches is not the reasonable cost of repair. You would have an expert who would come in and say, this is ridiculous. Look how good they can make these 2 scratches look, and that should be good enough for them. But coming into, if you're going to be working around some very, very, very expensive stuff and heirlooms and, Picasso's on the wall, you might want to get that exculpatory clause.
And it goes up in value after the damage. That's what I'm trying to say. You walked in, it was naughty pine. You walk out, it was teak. So
absolutely.
Well, let me share one more thing on that. I found in most states, under a liability situation, you do not owe replacement cost. You only owe actual cash value.
Right.
Which could be a pretty big deal.
Yeah, it could be.
If that floor is 30 years old and life expectancy is 30 years, you owe very little. If they put it in yesterday, you owe a lot more.
So there's a depreciation factor.
Absolutely.
But in Tennessee, a plaintiff is allowed to testify as to the value of their property without being an expert.
Really?
Their testimony can be accepted or rejected by the trier of fact, but it most often comes up with how much is my car worth, or what's the value of it, and they could come in and say those floors are worth whatever.
Okay, well, get that waiver signed.
Tyler, did you want to weigh in? You looked like you were trying to talk.
I think both Neil and Buddy definitely hit it on the head. In Tennessee, they kind of look at three factors in particular when they're deciding this, and this is going to be the function, the appearance, and the value, right? So if you scratch one piece of the hardwood floor and you can make it look as good as possible for that one scratch, in theory the appearance of it should be almost identical, and so you shouldn't be liable for the entire floor. But as Buddy has said, that's going to depend on what comes out.
Yeah, I think the phrase we're looking for is the diminution in value. The diminution in value. On the one hand, you're not going to fall through the floor when you walk across those scratches. It's purely an aesthetic thing. And what makes that more difficult is, if you have those 2 scratches, maybe does it reduce the value of your house if you were trying to sell it? I mean, you're not going to sell the floor. It's got to be in the context of overall diminution. And it's hard in that situation. It's hard to say. Neil, how much would you pay on one of those?
Honestly, I have seen them replace a whole downstairs floor before. A lot of it depends upon the adjusters and that particular insurance company. And I've also seen them be very difficult on it and say, we're only going to pay for a piece or 2. And a lot of it depends on if the wood's still made or the floor's still made. And I have seen us get out of them for less than $100, and I've seen us pay $25,000 for new floors.
So some of the things we're doing in the industry now, and I know a lot of us are doing, we're taking pictures of the work area, taking pictures of the floor protection when we put it down, taking pictures of where the appliance was when we arrived, things like that. And what do you think of those, Neil? Are they any good?
Everything you do, document pictures. And I know you can't just wear your tech out, document, but document pictures, anything you can do. If there is a loss that's presented, the better off you are. And I think the 2 attorneys will agree with me on that.
I agree 100%. So easy to take pictures and even videos these days. Walk around the thing, with a short video.
Tyler?
Yeah, I mean, all that stuff is going to be both on the filing the claim side of it, but then as well, if there's any lawsuit that comes in afterwards, having that stuff is invaluable. That's the type of thing that can nip a lawsuit that would have gone on for 6 months in 5 weeks. So absolutely.
And let me add something right there. Routine, doing this at every stop, having a written, this is what our techs do at every stop. Any of that documented in your employee handbook, all of that, I think you're able to say, hey, we do this on a consistent basis. So I believe all that's important as well.
It's kind of like when you take your car in to the dealer to get the oil change. They walk around the car and mark if there's any marks so that you can't accuse them of something when you're done. It's part of the routine.
Or when you rent a car. When I rent a car, you've got to do the same thing.
Yep.
And that may be another good example. Walk that area where that refrigerator is or that washer and dryer is with the customer and say, you know what, I see that right there. We're going to document that.
So one of the questions I wanted to move into a different area because frequently we, I want to say, deal with customers who are very helpful. So customer wants to help with the repair, help with moving the appliance, get in there while you're working on it, and he gets injured. What do you think of that, Tyler?
That's going to be that is about as many issues as can be wrapped up into one question as I think possible.
I thought it was neat. Yeah.
yeah. I think, to be honest with you, I think Buddy has seen a lot more of that than I have, because that is the exact type of issue, especially if it's a serious issue that's going to involve a lot, if there's any claims or any lawsuits that result from that.
Now let's just say this is not an invitation. This was not an open invitation. Please come over here and stand over my shoulder while I'm trying to work. This is just somebody who's got to be in the middle of it. What do you think, Buddy?
Tell them to get away from me. That I'm
That's
doing
easier
this. But
said than done.
I would turn to them and say, not only are you in my way, you're making me nervous. And if you really want to help, you're going to have to make sure you have that waiver of liability. I just wouldn't let them. I wouldn't let them help. I mean, I just wouldn't. You bring enough workers. I mean, if it's a 2-man job, take 2 men out there. What's that person going to do? I mean, he can stand there and point out certain things. Hey, look at this, this, and this. But if he hurts himself doing that, you're not liable for that.
Okay.
He's assuming the risk of, I mean, he's not your employee. And if he's just voluntarily helping you, you're not going to be responsible anyway.
Neil, has something like that ever crossed your desk?
Absolutely. Trying to think any specifics, but
Sure.
We have seen that.
Okay.
I don't have any examples off the top of my head, but we have dealt with it.
I think that your workers got to be trained not to if they can't stop it, not to in any manner encourage it.
Right. Sure.
Like, let me grab the other end of this. Well, you should have enough manpower out there anyway to do that. If it requires 2 of you, then you probably don't have enough people out there. I think it should be discouraged anytime it happens. And
most techs don't want homeowners standing over their shoulder, so it's.
I don't.
It's
I don't want my client standing over my shoulder when I'm working. I don't.
A real quick follow-up question to the pictures and videos. Can you take those without a customer's permission? And what if they say, no, you can't take a photograph? What are the ramifications there?
I guess it's there. You're an invitee in their house, but the scope of your invitation is to repair something. And if they take the position that taking photos of their stuff is outside the scope of your invitation, and that makes you a trespasser, I guess they can, but who wants to work? Let's say they go in and want to take photos, and your worker, your repair person sees things that he might want to note are already there before he gets started, and the homeowner says no. I don't think that's anybody you want to do work for anyway.
Right. And would that be something you could easily put on the bottom of your invoice? with your liability waiver? Just we will take pictures to document
Yes.
any. Okay.
Yeah, by signing the work order or whatever, you are consenting to our taking photos of the work area. We will not share them with any, just with anyone else if they have any privacy concerns.
At the very least, I would say if you have
They don't want it published. They don't want burglars to see what they have in their house, but I understand that. But just for the, with some
We see a lot of pictures
confidentiality.
that people take on Facebook where they're like, I ran from this house. So I don't think that those were taken with permission, but this was a question.
It's definitely a tricky line, but I would say that if they do refuse that, that's the type of situation in which your techs and your employees need to go document something somewhere, whether it be on whatever the deed that the homeowner signed, whether it be on however they take notes or do anything. Say, we requested to take pictures of this, it was refused by so-and-so, so that at least if something comes back down the road, kind of like Neil said earlier, any documentation, especially something out of the ordinary like that, make some type of documentation of it, both for if you have to file a claim, but also if a lawsuit happens later on down the road.
So I just got a quick, I'm sorry, Renee. I just got another one.
No.
Do you think body cams are the way of the future, or do you think that that's way too much? This was a submitted question.
Well, no, I'm going to weigh in a little bit on this because that's something I've thought about.
Okay.
It's crossed my mind, in
Well,
those
because you
times.
get the damage, but you also could get harassment or, assault.
Yeah, situational stuff. Plus, if some complaint comes back to you about a behavior, if you've got it documented on a body cam, then that shuts it right down. Or you become keenly aware of something your technician's doing in the field that's not what you want him to do. So, I mean, I've thought about it.
I personally like the idea. I think, I don't know how many claims I see come in here. In fact, I had one today that they were working on something. They pushed the refrigerator back. Everything's fine. Weeks later, they said, when you pushed my refrigerator back, the water started leaking.
Mm-hmm.
It flooded our floors. He didn't touch the water. He just simply pulled the refrigerator out and pushed it back.
Well, and that could also go into work comp, couldn't it, Neil? Where you're pushing the refrigerator, all of a sudden his back hurts.
Yep, absolutely.
That actually brings me to another question that is right in the center of what you're talking about, Neil. Is my question is, do we as people coming into a home to work on something have a reasonable expectation that what we're working on is serviceable? For example, if my technician turns their water valve off at the washer so that he can work on it and take the hoses off, and it breaks off in his hand and floods their house, is that on me, or is it on homeowner for letting it rust to the point that it's going to break off when somebody tries to use it?
It's on the homeowner, in my view, in that situation, unless the condition was so obvious that when the repairman comes in, if I touch this, it may come off. I think that's on the homeowner. I really
Neil,
do.
I know you've seen that.
We have seen that multiple times, and my concern for those is the insurance company, and maybe the two attorneys can speak on this. If it's $4,000 or $5,000, they pay them. If it's more than that, then they tend to fight them, and that's another issue all within itself.
Yes, it is. I will agree with you.
And then losses start tacking up against the appliance repair dealer. And then the next thing you know, your general liability is going up or you're getting canceled. And then you got another whole problem on your hand. So
Sure.
Anyway, I've seen them. I would tend to fight them or help you guys fight them versus turning a claim in right off the bat. But you do run a risk of jeopardizing your insurance coverage if you don't notify the insurance company of a claim. So,
yeah, absolutely.
You got a lot of variables there.
Tyler, what do you think? Same situation.
Yeah, it's it's always going to be that fine line of the difference between turning in something for a claim and whether or not you might have liability for something on the back end. $4,000 or $5,000, at least in the work comp, third party administrator, workers insurance compensation area, is a settlement that they're going to take, 9 times out of 10 just to be done with it most times. I mean, we offer that in nuisance value day in and day out. So
Sure. Yeah.
it's a simple of, I don't want to deal with it, and it's not worth my time. It's not worth paying somebody to go fight it or do an investigation or anything like that. So, if you're concerned about your loss ratio, somewhere else, then that's a little more on the business underwriting side, broker side of it. But certainly for small things like that, they're probably going to be paid 9 times out of 10.
But we're talking about business decisions and not actual liability. Yeah. As a pure defense lawyer, I would tell my client, don't pay that. You're not responsible. I mean, don't let them hold you for ransom. But it's a business decision at the end of the day.
I'm sorry. This is something I run into. In fact, I've just run into it, and I think I shared it today. You go out to somebody's home and you install a washing machine dryer. How long is typically that person responsible for it? I had a claim turned in the other day where 13 months after they installed a washing machine, the drain hose came undone, flooded the basement. They sent a subrogation letter to them and wanted them to pay nearly $40,000. How long are they responsible?
How long was the repair supposed to last?
Well, in this particular situation, they had sold the washing machine and installed the drain hose, and it had been there for 13 months.
It's a fact by fact situation. I wouldn't think you would be. The longer it's a moving line, the further away you get in time from the repair, the less likely it's a proximate cause issue. What was the proximate cause of it? After 13 months, can they really, and it's the plaintiff's burden of prove that your repair 13 months prior was the proximate cause of this. So the temporal distance between the two, the longer it gets, the less likely you're going to be liable. Can they sue you? Of course, as Tyler said earlier, if they've got a couple $100, they can sue you.
And let me add this. These guys, the servicers, are getting hit all the time from these subrogation companies. I would reckon to believe that just about every one of them have gotten some type of subrogation letter. If there was something that happened in the last 2 years and they made a call to that house, they're usually getting a subrogation letter. In this particular situation that I'm talking about, luckily enough, the gentleman that sold the washing machine was pretty astute, and they noticed that the zip tie that held the drain hose in was white. Well, this was a Maytag washing machine that they never had a white zip tie. They always came from the manufacturer black. So that homeowner had actually moved that washing machine, and they were able to prove that, and they did not have to pay liability on that situation.
And those are going to be the facts that are just that will come out in every single case, whether it's a zip tie, whether it's the hole was too big, whether there was a minor earthquake and it moved it a little bit. Those are all going to be the facts that will, we unfortunately have to give the lawyer answer of it depends. There's not a law out there that says after 8 months, no techs are liable for anything, anymore.
Let me speak from personal experience. 2 summers ago in the house that we were selling, we had a slow leak in the hose in our washing machine. So we got on the internet and had a guy come out, and he said, you need that hose replaced. It's cracked or whatever. So I'll replace it, no problem. You just take off the back and you put the hose on and all that. So, and he wasn't with a big company, which was my mistake. So the first time my wife washed clothes, this is a big washing machine, that hose came off and it flooded our kitchen area, into the basement, into our crawl space. I mean, it was an absolute mess. We had to basically vacate the house. They had to bring in all the Servpro or whoever came in, all the fans for about a week to dry everything up. And we were just putting that house on the market, by the way. So that was fun also. So my insurance carrier, which I believe is a very, very, very good carrier, paid for the damages that we submitted, and we got reimbursements for things like having to go to a hotel and wash clothes and things like that. So they let me stretch the causation pretty far. So they ended up paying, quite a bit of money, several $1,000s, to both Servpro and to us for our out of pocket. And at the end of the day, I said, all right, y'all are going after this guy. Here's his contact information, everything. Get your money back. And they said, honestly, we may send a letter, but if he doesn't respond to it, it's not big enough for us to refer it to an attorney. So coming all the way back around to the first thing that Neil said is that he sees these repairmen getting subro letters all the time. If the amount's small, if you just send them a letter back and say, nope, you're probably not going to hear anything else about it.
That's good information.
Do you recommend, Fred, that they respond and say no, or that they just ignore it? I mean, I know this is not legal advice. You're not giving advice to anyone in particular. There's the disclaimer.
I think frankly, frankly, yes. And here's what I would do to further discourage it. Just again, I'm not selling myself here, guys, but if you've got a lawyer, just have a form letter. We've investigated, the circumstances that caused the loss and your command for subrogation and do not see any liability on behalf of this repairman. At that point in time, the insurance carrier has to evaluate what a cakewalk it would be to get a judgment against a non-represented party. All of a sudden they say, I'm even going to have to take on this lawyer. I think it lessens the chance that you're going to hear anything else. A gigantic loss, they probably will, but my carrier said it's just not big enough to me.
I really wanted to. While our time is we still have a little time left, I want to talk about some workers' comp questions and some liability there with respect to a couple of different situations. Sometimes, and I hear this frequently too, one of the things that happens in our industry, and probably a lot of industries, is that we'll hire someone for the job, and we're going to stick with the technician's job because I think that's where the most liability is. And over the course of the first 6 months that they work for us, they've told all of my techs and half my staff that they got into an accident when they were in their 20s and stayed laid up in the hospital for 6 months and hurt their back really bad and recovered from it, yada, yada, yada. They went out next week and now I've got a back claim. Okay. Workers' comp. Where do I stand on that? I know now that he had a pre-existing condition, but when I hired him, I'm not allowed to ask that. I can ask, can he do the job? And he can say yes or no. But now he's told everybody in my office that he's had this situation. This is not an actual genuine person that works for me, by the way.
I think so. You went through my claim files. Mm-hmm. I was joking. You went through my claim. We deal with it.
I'm sure you do. So where does that leave us? I mean, we have information now, and I can't very well fire him based on what he's walked around my office telling everybody that he got into a motorcycle accident when he was 22. But now he's hurt his back lifting a microwave. Where does that leave me?
Well, how about it, Tyler?
So first and foremost, let me say, don't fire the guy right after that situation. There is nothing that is going to increase the cost of your workers' compensation claim like a retaliatory discharge claim.
I'm sure. Yeah.
Those are two kind of different things, but they go hand in hand.
Mm-hmm.
Now, workers' compensation law across the nation, and I know that you all have members that are nationwide, but workers' compensation is very state specific. So I'm going to use Tennessee because that's the one that we know and that we deal with day in and day out as an example. In the state of Tennessee, you take an employee as you find them. So that back injury, I know you weren't allowed to ask about it during the hiring process. I know that you may have aggravated that injury. That is unfortunately something that you as the employer can't necessarily get out of. Now, where that becomes incredibly relevant information is when a doctor is going to give their opinion about whether that back injury is or is not related to the work injury. Okay, so if you've got an individual with a prior lower back problem and he's got complaints for all this and he's got x-rays and he's got MRIs and you send him to a doctor, as in the state of Tennessee and most states you're required to do, your question is going to be, is that doctor going to say that whatever he needs or whatever he's experiencing is work related? At the end of the day, it's not going to be something that the employer can answer. It's going to have to be something that you're going to have to get a doctor, hopefully one that you trust or one that you know or one that your lawyers know to send them to help further that cause. But it's somebody in the state of Tennessee with a pre-existing condition, you take them as they are. And if your work injury injures their back more, that's something that on the front end that you're going to be liable for.
And his attorney is going to also employ a doctor who's going to say it was a result of something he did in my employ, correct?
Absolutely. Most likely.
And
somebody just
not to step on your
commented,
toes here.
Would you recommend a pre-employment physical? Would that help eliminate this problem?
Is it legal to ask?
Yeah. Is it legal to do, somebody commented, do pre-employment physicals. Would that be something legally you could do?
We have not seen those too much in our line of work in the state of Tennessee. And I know generally you have to be extremely careful with anything like that. And generally it's the job requirements have to tailor them to something very specific for something like that. Generally that's not something that I know that we or our clients are in the process of generally recommending. Let me put it that way. Your state may vary, but that's not something that we don't typically recommend.
Neil, how you feeling?
Let me add one thing right there. Most states now have a panel of doctors that you can post. I know Tennessee does. Make sure it's doctors you know, doctors you trust, and post those panels. And I think there's maybe even some defense there if they don't go to one of those doctors that's listed as a panelist. Tyler?
So absolutely correct. Yeah, they are. And this is not necessarily a workers' compensation, overview, but the long and short of it is Neil is 100% correct. You are required in the state of Tennessee by law, as soon as you're notified of an injury, you have 3 business days to provide them a doctor, 3 choices of a physician, and then they get to choose which of those 3 physicians that they go see. And Neil is absolutely correct. If they go outside one of those choices for any treatment, you have the defense of what's called unauthorized medical care, which would allow you to not be responsible for paying for that stuff. And that includes even if they go to their primary care physician for something. If they go outside of one of those 3 doctors that you've recommended, you have the opportunity to deny to pay for treatment that doctor did or that doctor has recommended. And there are steep penalties as well in the state of Tennessee and other states for not providing a panel of doctors, for not doing it timely, for not filing a first report of injury. So, it's not as glamorous as the big $50,000, floor repairs, but, the penalties in Tennessee can go up to $5,000 per occurrence. So they get pretty steep pretty quickly.
Well, and let's face it, there are doctors out there that are referred by lawyers.
Oh,
Typically,
absolutely.
Plaintiff work comp lawyers. And most of the time they get a neck brace and they get a lot of other things right off the bat. And so anyway, you just have to be careful.
And just to add a little bit of texture and maybe history to the workers' comp angle, I did a significant amount of workers' comp defense 20 years ago, up until about 17 years ago. And Renee, going back to your hypothetical, when I handled these, you're going to lose that every single time, because back then, all workers' comp cases were filed in our courts, just like they were a car wreck case, just like they were a breach of contract. You filed them in the courts and they were decided by judges who are elected every 8 years in these counties around here. What better way to shore up your support for the next election but by giving this local guy $100,000 for a tweaked back, and all of his friends and family and everybody's going to vote for you the next time. I got so frustrated with not ever being able to prevail on those. I just got out of it. I walked away. Now, the employers have done better. That all this goes through an administrative process now. Tyler knows all of that. I never bothered to learn it, but it is much more employer friendly now than it was. It was the Wild West back then. And I had a guy, the case that drove me out of it, we had an employee who only drove to go pick up his paycheck at noon on a Friday. That's when they picked him up. He didn't work after that, and drove off in a ditch, drunk as a skunk at about 10 o'clock that night near his house, 10 hours later. And the judge in Wilson County ruled that he was still in the scope of his work. And I said, it was daylight when he got there. It was 10 o'clock at night. He wouldn't tell me where he went and got drunk, but you know that he did, and that it was a departure from his course and scope. I lost it. I lost it at the Supreme Court. I quit. That was it. That was it for me.
And let me add this. In Tennessee, workers' comp rates are probably half the cost that they were 20 years ago because of this managed care and some of the things that they're able to do. When I first got in the business 30 years ago, I never wrote a policy voluntarily. I always had to go through the assigned risk. In the last 10 years, I've never written one through the assigned risk. But Tennessee has done a good job managing cost, and it's ultimately brought the cost of workman's comp insurance down.
And Renee, let me kind of bring this back here and to provide some advice, because I don't want to give the impression that employers or your members are necessarily helpless in a workers' compensation claim like this.
Sure.
What that employee has done since the injury, what that employee has told his coworkers he's done since that injury, that is valuable information that what we do and what other attorneys do on the defense side is we're going to write a letter to that doctor and we're going to say, we want you to know he's been doing this, or he's done this, or we've got video of him doing this. Those are all things that the employer can provide that is going to be critical. I know we had a case the other day where we walked in on a deposition and this employee was just putting on a show. And the next thing you know, we had sent out, a PI for a very low cost, pictures of him walking upstairs, carrying his groceries, doing all this, doing that, had told a coworker that he had to push his mom's car out of a ditch 3 days after the accident. That is valuable information that the employer, the coworkers, that if any of that is provided, I don't want to give you all the sense that you're helpless and it's just going to be a medical decision. It's going to be, but any information you can provide that doctor to help shore up your defense is valuable.
And their document. Yeah. Get the employee
document.
The time, the date. Get them to sign a statement. Any of that information is important.
And someone commented earlier that you, in the screening process, you cannot ask an employee, of course, if they have a disability. However, you can check to see if they've had prior workers' comp claims, and if they have, you can refuse or you can decline to hire a person because of their prior workers' comp claims. And the reason I know that is because that's my case, 2015 case before the Tennessee Supreme Court. They specifically ruled that you can. There's nothing wrong with refusing to hire someone because you know that they've had prior workers' comp cases.
And by the way, there is a system out there now that keeps up with all prior claims and liability claims. I saw one the other day. I don't know how you access it, but maybe through a background check, they can find that information out. Yeah,
there's a variety of sources out there that a simple name and social security number, which you're entitled to, can bring up more information. You'd probably be scared if you knew how much information could come up on you through some of these search.
If you get that file, you're going to know everything about that injury, exactly what it was, what caused it, whether your job, whether the person's been accused of being a malingerer. You may, if there's a hearing or trial, there may be some testimony on that you can get and find out from the other employer that this this person's a comp claim waiting to happen.
So you can do a background check for criminal activity, but can
Yes.
you legally ask them if they have prior claims or any background? This was a question just.
I wouldn't ask them. I would just look it up. It's
Okay.
public record.
Okay.
I wouldn't.
Search it.
Last question, because we've running out of time here. It's kind of a combination question. Somebody submitted one, but I want to expand on it a little bit. Sometimes we have customers who want a unit diagnosed just to see what's going on with it. If we tell them that it's unsafe to use, or if it is non-repairable and they go ahead and use it anyway, and it causes damage to their home or damage to a physical person in the house, how much of that is on us? And should we leave it in a disabled situation so they cannot use it? Is it within our power? Are we within our rights to leave it disabled?
I personally think if you specifically tell them, do not use this, it could be dangerous. I might film myself saying it to them, going back to Neil's, everything you can document, but that's,
Sure.
Unless it's something that they would need to actually live, like if you said, you can't get it in the refrigerator, no, we don't have anything to eat. I mean, that's a stupid analogy, but if it's something they can do without, say it's a washer or dryer for a few days, and they decide to use it anyway after you told them not to, that's on them. That's on them. And do you have to help them by leaving it disabled? I mean, help them not do something stupid. I guess you can do that.
That would be helping us, not them.
Yeah.
And I've seen situations where I knew when we left the home, the customer was going to use it anyway, period. Just, you tell them, you stress it, you tell them again, and you can tell by the look on their face the moment you walk out, they're plugging it in and they're going forward with it.
You write it on that invoice. Write it on that invoice.
Yeah.
Film yourself telling them.
Yeah, telling them. And if you can, tell them what might happen. This could kill you, something like that. Yeah, as long as you don't leave something that, if there's a kid in the house that looks like they may want to play with, I wouldn't, let's say there were exposed wires that if somebody grabbed, it would shock them.
Right.
And you said, all right, don't touch those, you'll get shocked. But they got a 3-year-old running around who might get to it. I'd be a little more careful there.
Yeah, well, that's an employee issue. If he's leaving exposed wires, we need to have a chat. That's really all I have. I told you this afternoon I could do 2 hours of this probably and still pick your brains for more information. It's just we wanted to touch on some things tonight. I knew I wouldn't hit everything. So if anybody's watching and I didn't hit on your question or your situation, turn it in. And if we schedule one of these again in the future, we'll ask it again and get you some answers. So thank you everyone for helping out with this question and answer session tonight. We appreciate it so much.
Yes.
Thanks so much for having us.
Thank you, Neil, Fred, Tyler. Thank you guys for joining us. And thank you for everyone that tuned in and that will rewatch it or watch it later that wasn't able to make it. And if you guys are interested in a second part of part 2, we'd love to have you back and answer more questions. So
okay, just let us know.
We
Seriously.
definitely will. Perfect. Thank you.
Okay, I'm going to leave
everybody.
now. Have a great evening. Goodbye.
You too.
Thank
Thank
you.
you very much.